A and British Broadcasting Corporation.
Lord Reid will summarise the judgment, which is the judgment of the court.
This appeal arises out of proceedings concerned with the deportation of a foreign sex offender. The proceedings began in 1998 when the Home Secretary served a deportation notice. They have not yet been completed, although the person in question, whom I shall refer to as A, was deported in 2012. In the course of the proceedings, an order was made under Section 11 of the Contempt of Court Act 1981, which prohibited the publication of A's name or photograph or other identifying details. The BBC challenges that order. It says that there is a public interest in its being able to report this case without restrictions. It concerns the deportation of a foreign sex offender. The proceedings have taken a remarkable length of time. There will have been a substantial cost to the taxpayer. A has in the past been the subject of publicity in which his name and photograph were published. Although it can report all other aspects of the case, its inability to reveal A's identity will detract from the human or journalistic interest of the story. All of that is undeniable. There is, however, another side to the story. A resisted deportation on the ground that he would be in serious physical danger in his country of origin because of the nature of his offences, the victim of which had also come from the same country. He would be targeted by vigilantes, something which indeed had already happened to him and his family in the UK following publicity about the case. The tribunal which dealt with the deportation proceedings accepted that there would be a serious risk to A if it became known in his country of origin that he was being deported there because of these offences. It held, however, that there would be no serious risk in the absence of publicity which identified him. It therefore made an anonymity order and authorised his deportation on that basis. A challenged that decision in judicial review proceedings in the Court of Session. At an early stage of those proceedings, A applied for anonymity in those proceedings also, and the judge made the order complained of. The BBC learned of the order and sought to have it set aside. That was refused. An appeal against that refusal was likewise refused. The BBC now appeals to the Supreme Court. It argues that the order is a disproportionate interference with its freedom of expression. It also argues that it was entitled to be heard before the order was made. A, with the support of the Home Secretary, argues, on the other hand, that the order was essential in the interests of justice because the tribunal's decision to allow the deportation to proceed had been conditional on anonymity and would be completely undermined before its validity had been decided in the judicial review proceedings if unrestricted publicity were permitted. That is because the effect of unrestricted publicity would be to give A new ground for resisting his deportation, necessitating a new round of legal proceedings at the least, and possibly rendering his deportation impossible to sustain. Furthermore, given that he has now been deported, and given that it has been found that publicity of this kind would place him at serious risk, A argues that anonymity is necessary for his protection. The Supreme Court unanimously dismisses the BBC's appeal. In its judgment, it emphasises the importance of the principle of open justice and the crucial role played by the media in ensuring that the courts are open to public scrutiny through their reporting of court proceedings. The Court, however, also recognises that exceptions sometimes have to be made to that general principle in the interests of justice. In particular, there are circumstances in which persons involved in court proceedings have to be allowed to remain anonymous. Some well-known examples are complainants of rape and other sexual assaults who might not otherwise be willing to come forward and give evidence, and undercover police officers whose effectiveness in future operations might otherwise be jeopardised. But less attractive persons have also sometimes required anonymity. In one previous case, for example, a prisoner serving a sentence for sex offences who wished to bring legal proceedings, but whose safety in prison would have been in danger if other prisoners had learned of the nature of his offending. In situations of that kind, the court has to carry out a balancing exercise considering the information which is sought to be withheld from the public, and weighing on the one hand the value of the publication of that information in advancing the purpose of the open justice principle, and on the other hand the risk of harm which the disclosure of the information may cause to the maintenance of an effective judicial process or to the legitimate interests of others. That is the approach of the common law, and it is also consistent with the Court's obligations under the Human Rights Act. Applying that approach in the present case, the arguments in favour of making the anonymity order are overwhelming. The order was made in proceedings concerned with the validity of the tribunal's decision to authorise deportation, a decision made on the basis that anonymity would protect A against a danger to his safety which would otherwise exist. The publication of A's identity in connection with the judicial review proceedings would have subverted the tribunal's decision, rendering the proceedings pointless. Furthermore, in the event of A's deportation, which has now taken place, the publication of his identity might create all the risks to his safety which the tribunal's anonymity direction had been intended to prevent. There remains a question whether the BBC was entitled to be heard before the order was made. It relies on Section 12, subsection 2 of the Human Rights Act, which applies where the court is considering whether to grant relief which might affect freedom of expression, and where the person against whom the application for relief is made is neither present nor represented. The court does not, however, consider that that provision applied in this case. The court was not considering whether to grant relief against any particular person. It was considering whether to make an order which would affect not only the BBC and not only media organisations, but the world at large, including, for example, bloggers, tweeters, and internet-based organisations. In that situation, it was not possible to give advance notice to everyone who might be affected by the order. Fairness did, however, require that anyone affected by the order should be entitled to apply to the court for it to be set aside, and that such an application should be heard promptly. That is, however, what happened in this case. The BBC was able to apply for the order to be set aside as soon as it learned that the order had been made, and its application came before the court only 2 days after the order had been made.